I'd like to take the opportunity to thank you all for the support and the encouragement that you have shown to me over the course of the last 10 years, particularly when I was serving in the Senate. We did not always agree on everything, but you had the attitude that we don't have to agree on everything in order to support each other. And I will tell you, I always supported you in the best way that I could. And for you all to have reciprocated it, and for the Republican Party of Lake County to have reciprocated it, was one of the most uplifting aspects of what I've done in public life. Is to know that we can all be one and together without necessarily agreeing on every jot and tittle of what goes on in the world. So thank you for that. You gave me hope that despite differences in society, we can move Ohio and our country ahead. Incrementally sometimes, but ahead, always ahead. Now, some of you may know, some of you may not know, that I am, as a judge and as a candidate for judge, constrained by ethical rules in what I can comment on and what I can't comment on. And there's a reason for that. Because when it comes to public policy, or the law of Ohio as it is today, or the law of Ohio as it may come tomorrow, if I start commenting on such things, the concern is that I will have displayed some preference for matters that may someday come before the court. And one of the most fundamental principles of being a judge and our judicial system is that we don't prejudge anything. Now, if that's a hard pill to swallow sometimes, because God knows I have a lot of opinions, right? And you may agree with them, and some of them you may not agree with, and that's okay too. But not to be able to express them out of a fundamental concern for the sanctity, and I'll use that word, the sanctity of our judicial position and the role that judges play in it constrains me, okay? And I also happen to think that the same goes for making too many or any definitive public statements about philosophy, political bent, political philosophy, social philosophy, or anything like that. Because at the end of the day, and you call me Pollyanna if you want, but I believe this, that our judicial system is blind to those things. That is to say, we rule on cases, we apply the law fairly and impartially to the best of our ability. And it doesn't matter whether we agree with a law that's been passed or disagree with a law that's been passed or may be passed or will be passed. It's a matter of adherence to the rule of law. And that's what I've tried to do as a judge, and that's what I will continue to try to do as a judge. So I thought instead I might offer to you some thoughts today about being a lawyer for almost 42 years, which practicing lawyer for 42 years, which I was, and being a state senator, and then talk a little bit about being a judge and what I've discerned about that and sort of draw some parallels and some distinctions so that perhaps you can formulate in your own mind your notions of what are you looking for this year as you vote for what are you looking for in a judicial candidate and what maybe is less important, okay? Now, as a lawyer, and as I say, almost 42 years, the last 10 of which also as a state senator, there were a lot of commonalities. First and foremost, to be purposeful in those roles, one has to put their constituents first, whether it's the voters, in the Senate case, or your clients as a lawyer. You have that responsibility to be first and foremost, everything else put aside, advance their interests, whatever they may be, so long as you can do it within the bounds of the law. And secondly, there were certain skill sets that I think are common between successful lawyering and successful legislating that I found to be helpful to me. Not to say that I was the arbiter of style when it came to those skill sets, but an ability to analyze and apply complex legal issues in a deep and thoughtful way, number one. Number two, an ability to express oneself orally, like this, and in writing, terribly, terribly important. Number three, to be able to understand that we don't always agree on everything, and therefore sometimes there needs to be some compromise. And fourth, I would say, is that the commonality was, as a lawyer and as a legislator, I was an advocate for those constituencies, whether they're clients, voters, the people of the state of Ohio, whomever, an advocate. And what that means is that as an advocate, when you're talking about the law, or understanding the law, or figuring it out, or you're talking about the facts of a situation that are presented to you, you have to, it goes through a filter. What's best for my client? What's best for my constituents? What's best for the people who I'm representing? And that's, it takes a certain skill set, it takes a certain perspective on things, which is to say, if I'm analyzing a statute as a lawyer, or I'm analyzing the facts as a lawyer, I'm interpreting them or trying to project them in a fashion that is most favorable to the interests of my client or my constituents. It's a high call, and it's not unconstrained, because lawyers and legislators, believe it or not, are constrained to make sure that what they're doing is within the bounds of the law, or within the bounds of what might be called a reasonable effort to change the law. The advocacy that goes on in lawyering and in legislating is advocacy about law, facts, and public policy. What's the right policy? And that's what I did as a lawyer and a legislator. Now, judging is different. And the difference is what makes judging, in my view, the most important function of our government, is the administration of the judiciary branch of the government. Why is well known to all of you. It's the most important because The judiciary is the last backstop. The last backstop against illegitimate legislative exercise of their powers, illegitimate exercise of the executive's powers, or illegitimate exercise of the administrative powers of government. It's the last backstop. And it's since the early 19th century, it's been clear. The judiciary is the last stop for interpreting the Constitution of our nation and the Constitution of the state of Ohio. So it's terribly, terribly important to understand the distinctions between what a judge does and what our judiciary system is about, and what the legislature or lawyering or the executive or anybody else does. And I'm going to understand that most of you don't need to hear this, but I'm going to say it anyway, because I feel it in here, and it's not clear to me that everybody who's associated with the judiciary system gets it, right? Number one, we're not advocates. We have a broad constituency, of course. We have the voters who vote in elections. We have lawyers. We have litigants. We have, a broad constituency. But we're not advocates for any body. We're not advocates for any particular position in a case that comes before us. We're not advocates for any particular view of the world, if you will. We're advocates for justice and the fair and impartial administration of justice. That's our holy grail. That's what we do. If we stop doing that, we're on the road to perdition. Trust me. Now, people will say, well, we need a conservative judge. We need some people in this country, trust me, would say we need liberal judges. Well, meaning what? If what that means is that the judge can be trusted upon, irrespective of everything else, to adopt a particular philosophy or a particular mode of analysis or a particular point of view in rendering decisions on cases involving real people, by the way, put yourself in this position. If what you think of as a liberal judge took the bench, would you want that person to be rendering decisions strictly through the filter of a political liberal's mind and shaping decisions to achieve the liberal agenda?
Obviously, no.
That's what they do.
It's almost a rhetorical question,
Yes.
and I don't mean to.
That's what they do.
I don't mean to pander, okay? And that is, in a
That's what they
sense,
do.
And I think we've heard many, many criticisms since I was a kid, right? In the 1960s, in the Supreme Court of the United States, and some of the things that they were doing back then. I heard it all the time. Okay, rail against it, right? Well, if I come to you and tell you, I'm an unerring, unabashed, conservative judge, and will continue to be, should you want me rendering justice through strictly a conservative Republican's filter?
Yes.
So, well, you might, but then you have to, then you can't answer the first question.
Well, now you're saying Republican, we said conservative, it doesn't necessarily mean Republican.
No, I
So
understand.
now you added Republican.
Well, all right, so conservative, okay? you can't answer both questions in different ways.
See what this is?
In my opinion. Yes.
What is it?
If I'm not mistaken, it's the Constitution.
The Constitution of the United States, and I don't have the Ohio one here either.
Well,
that's what you're supposed to render. You keep saying law. Constitution is what guides you.
The Constitution is the law of the state of Ohio and the United States of America, so it's included within the rubric of the law. Don't make any mistake about that, all
The
right?
question, is our current Supreme Court following the Constitution?
Which Supreme Court?
Ohio.
Look, I'm not in a position to comment.
You know
on-
what they're doing, though.
I am not.
Don't tell me you don't.
Of course I know. I know what I read in the
Are they
paper, and I know
following,
what's
are
going
they following
on.
the Constitution?
But I'm not in a position to pass on or make comment
And you probably
upon.
never will. Not that, because it's already at the Ohio.
Let him give his
I am
thoughts,
not,
okay?
I'll say it again.
I want to hear from John, not necessarily,
I just asked that question.
you asked it multiple times.
I understand. And I hope you appreciate what I said at the beginning. I'm not in a position to comment upon matters that are currently in the courts or matters that ultimately may come to our court. I can't and I won't, okay? But, trust me, when I say the law, I say the Constitution of the state of Ohio, the Constitution of the United States, and statutes are all part of the law that I'm talking about. So I take your point and I agree with it, right? Now, if we look at the question of who are a judge's constituents? It's not just the voters, it's not just the litigants, it's not just the lawyers, it's not just you folks, right, who have an interest in the outcome of matters and where they lead us. But it also includes the judicial system itself. Because judges are responsible, whether they like it or not, more so perhaps than anybody, in either establishing or enhancing or maintaining people's confidence in our system of justice. And in my mind, confidence in our system of justice means confidence that cases will be decided fairly and impartially on the basis of the facts of the case and within the bounds of the capital L law, okay? And without regard to how they might feel personally about a matter, without regard to how they might feel personally about the policies of the state. The policies of the state are established at the end of the day by the legislature and the executive branch, who you elect to make policy. Our job is to execute on that policy. There's also, I might say, as I've seen over the last 8 months, a singular difference between analyzing legal issues from an advocate's standpoint, as one might as a legislator and or as a lawyer, and analyzing legal issues from a judge's perspective. It has to be, as an advocate, as a lawyer, or as a legislator, the advocacy must be singularly focused on the interests of your client/constituent. The analysis as a judge has to be laser focused on justice, doing justice fairly and impartially. And that's, I think, a significant difference between a lawyer, a legislator, and being an effective and proper judge. And that's what I have tried to do. So, in some respects, I would say what's necessary for a purposeful role in society as a lawyer or a legislator, some of those things, ability to analyze things, ability to communicate in writing and orally, ability to identify issues and act upon them, an ability to interact with people and get their input. Many of that stuff is the same. And I think it all kind of falls under the rubric of, there was a law school dean who one time said, what you need to do this effectively is a good mind, a healthy body, a pleasing disposition, and a character that inspires confidence. All right, we all know what a good mind is. Doesn't mean you have to be Einstein, right? But you have to have a good mind, a discerning mind. A healthy body. And I will tell you, ladies and gentlemen, notwithstanding my addiction to nicotine, I'm doing all right on that score. At least so the doctor tells me. A pleasing disposition, I'll leave that to you. You're either pleasing or you're not, right? And so long as nobody's gotten up and left yet, I'd say close enough. Close enough for government work, right? And a character that inspires confidence. I think anybody's character will inspire confidence if they adhere to the constitutional principles that allow them to be in public service in the first place, that hew very unerringly, right, to the limitations that the Constitution places upon what they can and cannot do, shows respect to other people who have differing opinions about things, and who executes on what their responsibilities are. That's how you build a character that inspires confidence. So there are similarities between being a lawyer, a legislator, and a judge, but there are significant differences which I've tried to articulate to you today. And I'll tell you, as much as I said that judges don't make policy, and that they, in my view, don't, there is one policy which, to me, and I thought this before I was a judge, is immutable policy. Judges are to judge matters fairly and impartially. If you take nothing from this, I hope you understand what I'm trying to convey and understand that that is the singular most important principle and policy that our system of justice, since time out of mind, has had at the center of the discussion. God help us that we keep it there, okay? And when, I think, judges do that, I think they fulfill what is their highest purpose. And I'll tell you this, the highest purpose of any elected official, any person in public life, and that is to establish, maintain, or enhance people's confidence in our system of government. I'm not talking about confidence in Eklund. I'm not talking about confidence in DeWine or anybody else for that matter. I'm talking about confidence in our system of government. And because if and when we really lose that, we have a real problem, because that's where ulterior forces enter into our society to take advantage of that lack of confidence. We've seen it time and time again in the history of America and around the world, by the way. And adherence to the rule of law, impartiality and fairness in the judiciary is a linchpin for that confidence. And again, you've been very patient, and I'm going to offer myself to take questions if it's okay with you, David. But most importantly, thank you for having me. And if you can see your way clear to be supporter this year on the ballot for me, I'd be most grateful, because I would look forward and am very pleased to look forward to carrying out what I've been discussing for the duration of this term that I'm seeking retention to. Thank you all so very much. Okay, yes, ma'am.
Hi, I'm Kathy McAdams, I live in Concord, and I have a bunch of questions.
Okay,
All right?
sure.
You were co-sponsor of Senate Bill 6, the first energy bailout, $1.3 million of taxpayer money
think it was
to bail out a
1.3 billion.
billion, to bail out a $25 billion company,
That-
all right? You voted in favor of it, and my electric bill has gone up. I'm a widow. I'm a recent widow,
I'm sorry to hear
and
that.
my electric bill has gone up. Now, I'm lucky that I'm getting some of my husband's pension. I'm lucky that I'm getting some of his Social Security.
Sure.
But with my electric bill going up and up and up, and having to bail out a $25 billion company,
Yeah.
when I'm not even bringing in $75,000 a year,
Right.
how is that fair to other people in a similar position on an extremely limited income? I'm 66, I'm 5 months younger than you, I'm not going to get a job. I'm retired already.
Okay.
How is that fair to the rest of us taxpayers? To have to bail that group out when they didn't need it?
Well, I appreciate your situation. I do. I have a mother-in-law in a similarly precarious situation here in Geauga, down in Geauga. And I understand perfectly that there was some controversy surrounding that, and that subsequent events did nothing to reduce the controversy, right? And I don't think that I'm in a position to comment on the substance of the bill, but I hope you will understand that when one is in the legislature, there are many, many, many countervailing considerations to be taken into account. And
First Energy gave you $21,000 in campaign contributions that same year. Is that one of those countervailing situations?
if that's so, no,
Okay.
no,
All right.
no. If what you're suggesting is that, in that respect, that my head was turned by campaign contributions, you are wrong,
Okay.
wrong, right? Now, anyway, I can't comment. I know that there has been legislation passed since that has rolled back a lot of those provisions that were in that bill. I know that for a fact. I don't know what impact it has had on any consumer's bills, but it was a great hoo-ha to roll some of those considerations back. It was done, and the hope was that it would help ameliorate some of the concerns you're talking about. I wasn't there for that.
My electric bills have gone up this year.
No?
Not last, I'm not talking last year, I mean this year they've gone up, and it's gotta be due to that.
Well,
So
I
my
think
next
part
question.
of it may be, man, because the price of natural gas, which powers much of the.
Let's set some rules. Ask the question, have the candidate answer the question. We want to give everybody a
Yep.
chance to ask questions.
Fair enough.
And let's keep them to about a minute. We've done this before. We've said, try to make our comments at the end a minute, and then they become a 5 or 10 or 15-minute speech. So ask one more question. Ask the question and let him answer.
All right, one more question, and it's a combined question. You received endorsements from Ohio Right to Life and the NRA, and then voted against the heartbeat bill and stand your ground. Why?
I cannot and will not comment on why I didn't even list. I'm sorry.
Since I'm limited to, I have one more question, but since I'm limited to that, I will finish.
Thank you very much for your question. I appreciate it. Yes, ma'am?
My son works for nuclear power in California, and he was just saying when he heard about the bailout, he said, if you knew how much waste there was in these utility companies, and nobody holds them accountable. The money that they spend.
Good. Yes, sir.
So I got a question. I know you kind of made your thing so you don't have to answer a lot of questions from things you respond to.
Well, no, it's not that I have to.
It's my turn. It's my turn. Baloney. We had judges here before answering those questions. Good judges, constitutional judges. Now my question is, you're saying that judges are fair and honest and so forth. So you're telling me there's no difference between a Republican judge and a Democratic judge? Is that what you're saying here tonight?
No.
Well, then you're saying, then what are you saying?
What I'm saying is
You say all judges are supposed to be equal and
yes.
not supposed to make 8 judges. But look what's happening in Ohio, and we've seen it. We have seen where liberal judges interpret things that aren't in the Constitution, that aren't in the law, and they make it that way. Okay, and so it does make a difference whether you are constitutional or a conservative and not a liberal, as you have been known to be.
Well,
you can't comment on your stand your ground veto and your heartbeat veto and other things of that sort. You're saying you can't comment on it, but we see the law. We saw the veto.
I veto.
Not veto, but we saw how you voted.
But the difference is in doing what judges do, as I tried to describe it, there is a difference between the way a Democrat might look at them and a Republican might look at them. In terms of interpreting the law, in terms of applying the law, and in terms of, I think a Republican judge does what I've described. A Democratic judge has demonstrated himself to be, over the course of time, more inclined to do what I think is the inappropriate way to go about doing the job. So it's a fundamental difference in whether or not the philosophy I'm espousing is or is not embraced. That's the difference. Yes,
Can I just say something? In reality, I was on council for 10 years. And you know, I made decisions based on the information I had. Was the information always correct? No. Not always correct. And I've made mistakes. And you just have to go out and sort of say, gee, I made a mistake. It seems like nobody wants to say, I was wrong. Exactly. Get real, people. We all make mistakes. And maybe you need to say, yeah.
So, did you say he made a mistake?
I
He's
don't
never
know.
said he made a mistake.
I don't know if he did or not, but I'm saying
Did he make a
have.
mistake?
Well, I've made many mistakes.
There you
On any
go.
of these bills?
And don't say you can't comment on making a mistake out of it.
I don't think I made mistakes on those bills.
Okay.
No.
Then
But
stand
I
with
also
your deal.
acknowledge, there's plenty of people who disagree with me, for goodness sake.
But we're constituents. You said you support constituents.
352,000 of them in the Ohio Senate,
And you're saying that your constituents were against the stand your ground and against the heartbeat bill and for all these things?
my discernment was that the majority of them were.
Oh, wow.
Oh,
Oh, wow.
okay.
That's not what surveys always say.
Well, okay.
Oh, wow.
Yes, mate.
Hey Dave, is this a playground fight or are we trying to accomplish something here?
Yeah, I would
I
appreciate.
gotta hear, oh wow,
I
oh wow,
would
like a
appreciate,
3-year-old.
we've had 10, 15 candidates come in here, and I would think every one of us has something that maybe we didn't like about the candidate. In fact, I know there have been some candidates here that people told me they couldn't stand, but they were polite and not argumentative. I think we can ask a question, let the man answer. The great thing about this is, if you don't like him, you don't have to vote for him. That's the great thing about it.
You said he can't.
Don't be argumentative. Ask him the question that you want. That's why I can't run for office. I've said too many things. I've told too many jokes, and too many people know me. If you put me under a microscope, I couldn't stand it. And yet I feel like I'm a conservative person. So let him talk. I would like to hear what kind of appeals come to you, what kind of cases come to you, but let's ask a question, let's be civil.
I just want to make a comment.
Go ahead.
Faith Andrews, Lake County Clerk of Courts, but also constituent. Before I took office, you know, I have my own business, and I went to Columbus with a small business lobby. Cozy put together. It was Cozy Day at the Capitol, and I've been there several times. I just wanted to say, I mean, at that time you were in the legislature, and you were one of the only, you know, people in legislature, both the Senate and the House, that would take time to meet with your constituents. You made yourself available. You, personally, okay, not your staff or some underling. That resonated with me because you took time out of your day, and you know you're busy. I just know what your day is like, being an elected official at a local level. That always was very important to me as a constituent, that you did take the time, you, and not send anyone else. So thank you very much for always, you know, taking time out of your day to meet with your constituents. And we had very, very great conversations about economic development and different things that, you know, that you all could do to help make our lives better back here in Ohio. So thank you for that.
That's good. Thank you, Faith, I appreciate you recognizing that, and it goes back to, I think, one of the first things I said, which is, number one job, whether you're a lawyer, legislator, judge, your constituents come first. And I always took that seriously and continue to take it seriously, which is part of the reason why I'm here with you today. Yes,
A lot of us have experienced in Ohio that feel, many of us, that we watched our rights being eroded by the administration and the legislators. And I agree with you that in many cases, the judges are last line of defense for personal liberties and for the Constitution. And I read a lot now that we may be what many feel is in a post-constitutional America. And because of the erosions we see, and even when a conservative is elected, it seems like all they can do is maybe hold the line without ever recovering what has been lost in our society and how the Constitution is eroded. I would like to hear what you think about the situation where many feel we're in a post-constitutional America that we cannot recover back to those ideals.
all right. The fact that there are people and commentators suggesting that we're in a post-constitutional America is, to me, a reflection that we're falling down on the job to establish, maintain, or enhance people's confidence in our system. We're falling down on the job. You're not falling down on the job. The elected class, if you will, those people who hold that high responsibility are falling down on the job. And without spending another half hour talking about what that means, let me suggest to you that I believe in the world of judging, falling down on the job means failure to adhere to the constitutional limits of our powers, failure to recognize the difference between deciding cases fairly and impartially and making policy, and those two things in particular. And that's what we need to guard against when it comes to the judiciary. And that's what I pledge to you, is that I will guard against those things and continue to guard against those things. I think it's my constitutional responsibility. For goodness sake, I think it's part of the oath of office that I took. To uphold the Constitution of the United States, the Constitution of the State of Ohio, and to fairly impartially decide upon the things that are brought before us, right? And so I take your point. My comment on it is, it's a reflection of something that I've been trying to emphasize. Yes?
So what do we have to do to rescind the windfall law? I lose $300 a month in Social Security because I get a government pension.
Yeah.
And when is that going to change?
Never.
Never? You got that right.
Yeah.
Everybody says they're gonna do something, and nobody says
Every-
anything.
Other
Everybody.
year, you get all this email and support and
Everybody's gonna
and
change
nobody
it.
does a thing.
And I retired in 2012, and nothing has changed.
That's a policy that I've heard about.
Bad policy.
I appreciate your comment.
Some states have turned it around.
Some have.
I won't even consider it.
David, you wanted to hear a little bit about the cases that come before us? And I think if I
I
may,
think John has a question too, but yeah. What kind of cases come before you?
we hear appeals from every trial court in the 5-county district: Ashtabula, Lake, Geauga, Portage, Trumbull County. Municipal court cases, probate cases, common pleas cases, county court cases, the list, juvenile court cases, they all come to us. And in a large respect, you need to understand, we're kind of the last stop, right? Because all of these cases basically have, the litigants have a right to appeal to the Court of Appeals, and they do. And we don't have any choice. We take all the cases and we have to take them. There's a final appealable order, we take them. They are criminal cases, they're domestic relations cases, they're adoption cases, they are little cases, and there are big cases. And so we have to take them all. We basically do not reverse, at least statistically, the courts of appeals in Ohio. And there are 12 of them. Do not reverse a large percentage of the cases that come to us. Because frankly, your common pleas judges are doing, generally speaking, and your municipal court judges are doing a heck of a job, okay, in a very difficult circumstance. But of those that we do reverse, then the litigants can go to the Supreme Court of Ohio, or try to go to the Supreme Court of Ohio. But the Supreme Court of Ohio, for the most part, does not have to take any case. They evaluate them and decide which ones they want to decide and which ones that they don't. And it's a very small percentage of the cases for which review in the Supreme Court is sought that actually get reviewed in the Supreme Court of Ohio. And so, for all, I won't say for all practical purposes, but statistically, the courts of appeals are your last stop up the judicial review chain. Now, is that a good thing or a bad thing? Well, I will pass judgment on that. But it heightens the responsibility that judges on the Court of Appeals have. It heightens the importance of some of the principles which I've been trying to describe to you. Because there may not be another bite of the cherry from what the Court of Appeals does. There are 12 Court of Appeals, as I said, in the state of Ohio. I think there are 69 Court of Appeals judges in the state of Ohio, and they're all on equal footing with the 11th District Court of Appeals. But there's no limit on what you can come up with us. We've had traffic tickets come before us. We've had felony murder cases come before us. We've had, cases where people are sent to prison for 10 to 20 years come before us. So you're dealing not just with life, you're dealing with it all. Life, liberty, and property. Yes, sir.
Thank you for coming here, Judge. We really appreciate it and giving your insight. Very important to us. Kind of piggybacking off of what Dave was talking about is when you are reviewing a case, what process is involved with that? And I mean, what people are involved, you have like people doing research for you guys, you discuss matters between the judges, like what's that process?
Well, it's a very collaborative process. Number one, the case comes in, the parties in the case below, they decide what part of the record to send to us to make part of the appeal. And that comes in, and it's organized, and through a relatively random process, the principal responsibility for a case gets assigned to one of the judges, right? That judge has a secretary, 2 judicial attorneys, and the process begins of reviewing the record that's been presented to us, doing the research, and the parties file their briefs. Those are reviewed, the research is checked, and I'm doing it just as in tandem with my judicial attorneys, right? So once we've gone through that, we get together and we talk about the case and how do we think it goes, and we start to formulate a preliminary view of the world, right? And between the 3 of us, we ultimately come up with what I call a review brief, which is essentially a draft opinion of how we think the case should come out. That gets circulated to the other judges who've been assigned to the case. There are 3 judges assigned to hear each case. So,
Initially.
Initially.
So it doesn't go to the full.
No, it does not go to the full 5-judge panel. So we come up with that idea of how we think the case should come out. We circulate it to those judges who are also going to participate in the decision, and they have a chance to look at it. And if they have questions or thoughts or comments, they can come to us and say, hey, I understand this, but I don't get this, or I think this is wrong, or this is right, and we can adjust that all along the way. But no decision at that point has been made. So at some point in time, the case is scheduled for an oral argument, where we give the lawyers the opportunity to come in and argue their side of the case to the 3 judges. And we ask questions, we get further information, and then there's a process after those arguments where the 3 judges get together and conference, which is to say, we talk with each other about what do we think of the case now that you've seen Eklund's review brief, you've heard the oral arguments, what do we think of the case? And sometimes in that conference, we come to an agreement about how the case should go. Sometimes we don't. And if we don't, sometimes it's, well, let me think about this some more. And people go back and think further and then ultimately get together, and you hope you get a decision. Now, it's an interesting twist, and I'll share this with you. You know, if a case is assigned to Eklund initially, and we do our review brief, and we circulate it, and we have oral arguments, and everybody, the other 3 judges hear it, and the other 3 judges say, no, we disagree. The other 2 judges say, no, we disagree. Well, sometimes what happens is I can reassess the opinion to address their concerns and maybe get them on board with it. But if not, I can say, well, I think I'm right as rain on this. Then one of those 2 other judges then becomes the majority opinion writer, and my opinion becomes a dissent. So it's a very fluid process, and until the judges officially vote on what to do with the case, which can be many weeks after the arguments, the case is not decided. And what has been very gratifying to me is the extent to which there is interaction between the judges deciding the case on what is the right thing to do here. And sometimes it's somewhere along a spectrum. You may go from this part of the spectrum over to this part of the spectrum through discussion with your colleagues and your law judicial attorneys and the judicial attorneys from other chambers. And there's a great collaboration and an effort to make sure that we're getting it right. It's a good question. Well, you've all been very kind. Yes, sir.
Hello, my name is Hal Werner. I'm the president of the Heritage Club of Northeast Ohio.
Yes, sir.
And that is an association that believes in Christian concepts and the basic fundamentals of how our country is derived upon, and how we, as members, stand up for this and have guest speakers every month. Obviously, there are many questions here today of concern. Appreciate you commenting and speaking. And Sarah Kovar came to our meeting last Thursday, week and a half ago. And I would personally like to arrange to have a debate with you and Sarah Kovar, perhaps within 2 to 3 weeks. And I'm checking into Harvey High School, which is a very great high school, brand 10 years old, seats capacity about 300 people. And I would direct this, and just wonder perhaps if you would like to do this. She's willing to come.
Al, could we coordinate about that, please?
Yeah, let's coordinate with Alex. Alex is with my campaign, and the schedule is paramount. So let's discuss that, see how it goes, and we'll move from there. All right?
Okay, I'll be.
I don't reject it out of hand.
No? Okay, because there are 5 counties involved, obviously, that you represent. So I'm sure there's questions with many, many voters, Republican, conservative voters, I'm going to say, because of the primaries. And I think it would be very beneficial if more and more people come and to listen what you have to say, and Sarah. And I think that would be...
I'm all for an informed election.
Okay, Alex, I'll be
Thanks,
speaking
Alex.
to you. I need your card and phone number.
Okay.
Thank you.
John?
Thank you, Your Honor. I have to say, I feel it's laid upon my heart. As a Christian, we're called to testify about the things we know. I believe there are things that I can say that you can't. I can comment as a councilman and a council president, as a commissioner president. You've always put substance over symbolism. That's important. Because when you have to implement the laws that others are saying, here's the law, here's the rule, that's very helpful. Substance can be applied. Substance can be corrected. Symbolism, not always so much. In the circles that I travel in, you're often referred to as the good senator, and now the good judge. As our clerk pointed out, you're approachable. You take calls and you follow up. Those are powerful, powerful attributes. You're a humble man, and I dare say you are a humble servant. But something that's very important to me personally is justice must be independent to be effective. Anything less is the foundation for a constitutional crisis. You are a good man.
Look,
That'll be $100.
Checks in the mail.
thank you for that, John. And look, folks, you know, I've been in elections before, and I've won elections before, and I know there's disagreements. I know there's people who, you know, have voted against me in the past and will vote against me in the future. Nobody ever won one 100% to nothing. Nobody, right? And I understand. And to me, again, this exercise and this campaign process, to me, sure, it's about securing people's support and votes and all that stuff. But more importantly, it's just another way, as far as I'm concerned, to help people to appreciate the different roles of different people in government, different positions in government, and to be thinking about them as they make these important decisions. And if that goes any distance towards maintaining or enhancing or establishing people's sense of confidence in our government, I will have accomplished what I'm trying to do. Okay? So, Commissioner?
Professor, there are some things that Professor John can say about the law that Judge John cannot. I've heard a couple of you comment, I've heard other judges address these issues, and I'm sure you have. Because the rules of judicial ethics in campaigning are not enforced very well. They're not. And so it's very easy for someone who has lessons to tell you what you want to hear and answer questions they're really not supposed to. Because the only person enforcing those laws are usually you yourself on you yourself. So when you see someone who goes the extra mile to hold to those standards, even if it might hurt them because they can't answer a question that they're burning to, they have what they feel is a good answer, that tells you something about their character as a judge. My question isn't so much for John Eklund, but it's for all of us collectively. Do you want the most conservative judge? Do you want the most conservative judge? And if the answer is yes, Judge Eklund can't tell you who that person is. Judge Lynch can't tell you who that person is. Justice Kennedy, no judge, no justice can tell you because they're not allowed to make endorsements. They're not allowed to say who is the most conservative or opine on political issues, and even though some judges do, they know it's wrong, they just figure they'll get away with it. Very rare that the judges get slapped for it. They just figure, I'm in the black robe, I can get away with anything. And you know what that is? That's an activist judge, which my definition is a liberal judge. That's right. The most conservative judge is the one who follows the law, which includes the highest law, the Constitution of the United States. And we should be furious at the liberal judges and justices that we see today. I will go a little bit further than anyone today in saying that anyone who thinks that they can come up with fake rights in a penumbra that doesn't exist so that they can kill unborn children, to call them a liberal judge would be too kind. To call them a lawbreaker might just be about right. To call them a murderer, more correct.
Amen.
But a professor can say that. A tenured professor can get away with it. Even a conservative tenured professor can get away with it. I like to use tenure against them. But a judge can't. Because it's very possible that Judge Eklund will have a case in front of him dealing with the laws of abortion in this state, dealing with the laws of life in this state. And if he talks about it, let me tell you what happens. Let me tell you what happens. If someone taped this meeting, and he were to talk about it, then guess what? When that case comes in front of him, if I'm the lawyer arguing that case, I say that judge is biased. I have a videotape of what the judge said, and I want him off my case. And even though he might be the only good conservative judge who would rule the right way, he's off that case because he thought it was more important for him to win an election than to do the right thing. So when you hear a candidate say, here's how I would rule, or here's how I feel about the pro-life issue, the Second Amendment, what they're really doing is they are penalizing you and every constituent, because when they get that all-important issue in front of them, a good lawyer like me is going to say, you're off this case. And if I've got a videotape, if someone's taping that conversation, I'm going to win easy. Now, let me say something about HB 6. No one can accuse me of being Larry Householder's friend. He spent a lot more than $21,000 to say no to me. The number is probably in the hundreds of thousands, to be honest. But I will say this. One thing I supported from square one and two today is we need to keep the Perry nuclear power plant open. A lot of people rely on those jobs. And by the way, it is profitable, whatever anybody told you. And some of those lies came from First Energy or Energy Harbor, or whatever the heck you want to call them. They were profitable the whole time. But as the good councilwoman said, a legislature makes decisions with the information they have at the time. And what Mr. Eklund always did as a senator was support Lake County. He may be from Geauga, but he always supported Lake. And let me tell you, every single elected official in Lake County said, we may disagree on the solution. There's a lot of ways we might address this problem, but every single one of us, myself included, said we can't let that power plant close. That would be terrible for our economy. It would be terrible for energy independence, something that we're seeing all the more important now as Russia tries to squeeze us through their energy policy. So I may not agree with HB 6 or one particular bill, but I know that our senator fought hard for Lake County to make sure that power plant stayed open, even if I might not 100% agree on the solution he chose to do it. I will tell you this too, I have never seen a braver elected official come to a forum where he knew he was going to get the most difficult questions, and frankly the moderator had to say, let's tone it back. It's always the speaker, it's always the candidate who says, well, I'm not going to answer those questions. But the judge here, to the best of his ability, kept on. You'll never see that again, mark my words. When people think they're going to get a tough crowd, they usually don't come. So this is actually a very rare thing that we're seeing today, that the judge was ready to come and answer those questions as best he can. Even though he knows you don't want to hear, even though he knows he has to say, I can't comment on legislation. I can't comment on an issue that might come before the court. And by the way, redistricting could come before the Court of Appeals. You know how many times
Can you tell me one subject that can never come before the court?
It's hard to.
Give me one.
A subject that could never come before
Yes.
the court? Whether or not you're allowed to drink coffee this morning
Okay, so,
in your private house.
so he can say, I don't want to talk about anything because it can't be covered before.
No.
Tell
You
me
can't
one.
talk about an issue that might come before the court. But what a judge can talk about is their fundamental judicial philosophy.
And he voted against the heartbeat bill, which is
legislation. Which is legislation.
Exactly.
And you can reach your conclusions
And it
based on his
passed.
past
And
votes,
it
but
passed
you
Ohio.
can't
So
vote.
he was not in.
He can't Elliot, he can't speak on that vote though.
He's been speaking for 5 minutes. Okay.
Okay. And I'm a professor, so I could speak for 3 hours and not lose my win. That's another great thing about being tenure.
We've noticed, John, we've noticed.
But let me say this in closing. What you saw today was brave. You saw a true conservative who did not tell you what you wanted to hear. A conservative judge does not say what they're going to rule on an issue before they rule on it. A liberal judge has an agenda and pushes it. And don't get me wrong, I'm sure that if I were in the legislature the same time as John, that we would have voted differently on some things. I'm sure that you would, and you would, and you would, and I'm sure you would have disagreed with me. Pointing out one or two things you disagree with rather than a body of work that you agreed with most of the time is a real failing. And I'm willing to bet you that whoever that other person running is, you'd probably disagree with that person on a lot of things too. So, the point of...
Now let's talk about House Bill 256, the youthful violent offender probation that you were a co-sponsor for. You know, none of what he did as a senator was conservative. That's my point, I'm done.
Okay, you made your point, and everybody checked that off. We want everybody to express their opinion, but we would like a forum where we can ask questions. I always like to end with, John, did you have a question?
I have one
One comment?
I've talked before at various other meetings, and I just want to pass it on to you. The people here in Lake County, and like I said, we talked about it, there's 3 parts to enforcing the law. There's law enforcement, our prosecutor, and our judges. And as you said, eventually if we get about us speak about the county, we have, in my opinion, a great sheriff, we have a great prosecutor, and we have great judges in Lake County. And everything, all that I believe that the people of Lake County want is a just, fair, and impartial verdict, but we want our laws enforced all the way to the end, regardless who you are or whatever. I think that's what the people here in Lake County